Thank you for staying with us, and a warm welcome to those who've just joined us. Now, the Competition Commission is planning to prosecute Sasol Gas for excessive pricing of natural gas. The Commission says it has followed complaints levelled against the company. It's alleged that Sasol is pricing natural piped gas by at least 72%. To discuss this further, we are joined by Yongama Njisane from the Competition Commission. Yongama, thank you very much for your time here on eNCA. Just first of all, in terms of your investigation, did you, for instance, find that they colluded with anybody, or are you still investigating that?
Good afternoon, and thank you for having me. Essentially, the investigation essentially just focused on this allegation around excessive pricing. We did not, in terms of the complaints before us, have issues in relation to some kind of collusion.
And their explanation, what did they say when you were asking them questions around this?
We have actually conducted this investigation without the benefit of Sasol's cooperation. As a matter of fact, when we approached them to ask them to respond to some of the issues that were raised, they essentially did not respond to our information requests. They also, when we then put out a summons to compel them to respond to the charges that have been laid out, they essentially approached the competition tribunal to suspend the summons. And that is actually a process that culminated with the competition appeal court about a week or so ago, putting a pause on us executing our summons because of an ancillary issue where they were contesting our jurisdiction to actually investigate this matter, particularly given that they are under sector regulation by the energy regulator, NERSA.
So then, was it a disrespectful move, do you think, to not answer the Competition Commission while being investigated for something so serious?
Well, we are concerned, obviously, by firms who seek to not cooperate in investigations. One, because it is important that they should have an opportunity to put their side of the story. We do see this as a delaying tactic because if you think about the background of this matter, it is not just about the Competition Commission investigating this matter. It actually goes all the way back to about 2014 and how the industry had actually gone through various courts expressing concerns about the pricing mechanism in place that was allowed by the energy regulator, culminating in 2019 with the Constitutional Court, which basically said that the pricing mechanism was not appropriate because it did not take into account Sasol's costs, and so it allowed Sasol to actually extract more than was due to it. And so that process is still ongoing. There are continuous challenges in relation to NERSA's maximum price. Yeah. But in parallel to that, the complainants also approached us as well.
Yongama, this must have had a detrimental effect on business. I mean, piped gas is what we use, for instance, particularly in our context in South Africa, to keep the lights on through generators, etc., especially because of what we're going through with our energy crisis. So obviously this was, a planned strategy perhaps by Sasol now that you found them guilty, and it must have had quite a detrimental effect on business.
We are quite concerned, as you correctly say, given the energy crisis that we face. Anything that actually impedes the ability of business and households. In this instance, perhaps, it's important to point out that natural gas is not just used by big business, it is also small businesses, bakeries, for an example. In Gauteng in particular, you have households who actually rely on natural gas, who are also affected by this conduct. And so it's important, in light of the energy crisis that we are facing, that any steps we can take towards ensuring that consumers can access, consumers being obviously business and households, can access energy at cost or at cost reflective or competitive prices is a very important thing for us.
Yongama, obviously I know that you plan to prosecute Sasol Gas for what you found was price fixing of 72%. That is quite huge. But what other punitive measures have you taken against the company for now?
So at the moment, the process, so it's almost like running two parallel processes. We still have the process in terms of their challenge their challenge on our jurisdiction, which is to be heard at the Competition Appeal Court. We would like that matter to be heard as soon as possible, because we think that it is important that the pricing issues in this sector are resolved. And then, of course, once that is sorted out, then we would hopefully having the appeal court finding in our favor in line with what the competition tribunal has already done, we would then be able to proceed with the referral which we've placed before the competition tribunal for the merits of this matter to be heard. In relation to this. And typically what we would ordinarily do, as the law allows us, is that when firms are found to have contravened the Act, we are able to levy a fine of about 10% of their affected turnover. And we may also be able to recommend behavioral remedies. So, for an example, in this instance, you could be looking at revising the pricing approach that is followed by Sasol, so that it is reflective of costs and a fair return on their investment.
All right, Yongama Njisane from the Competition Commission, thank you very much for your time here on eNCA.